Hey guys, my name is Andrea. I'm the Legal Practice Director here at Genuine Legal WA. Today I'm going to discuss wills with you guys. So simply put, if you don't have a will when you die, you don't have a say in how your estate's going to be administered when you do pass away. So that's called dying intestate, or dying without a will. So when you die intestate in Western Australia, Section 14 of the Guardianship and Administration Act 1990 provides a legal formula which dictates who will benefit from your estate when you've passed away. So, by example, if you die leaving a spouse and some children, the first $50,000 of your estate will go to your spouse along with the chattels that you own, and the balance is split 1/3 to your spouse and 2/3 to your children in equal shares. Now, another example, if you die leaving a spouse and no children, the first $75,000 is paid to your spouse and half of the balance left over, and the other half of the balance left over is paid to your surviving relatives, like your parents, your nieces and nephews, those sort of people. So this might not be how you want your estate distributed, particularly if you intended for your surviving spouse to take the full portion of your estate. Now, if you don't have any living relatives when you die, and if you died without a will, the government will take your estate eventually. Again, that might not be practical if you wish to donate your estate to a charity, for example, or to some sort of agency, in particular if you don't have any living relatives or a spouse. So obviously, to avoid circumstances like that and have control over who benefits from your estate when you pass away and that your wishes are carried out, you really do need to have a will. So a will is a legal document that sets out your wishes regarding the distribution of your property and your estate assets when you die. Having a will also allows your beneficiaries to access your estate assets sooner and easier, allows them to make an application for probate as opposed to an application for letters of administration, which is what's done when you die intestate. And a letters of administration application is a much more drawn out process and complicated process than making an application for probate, which is what you would do if you did die with a will. Creating a will also ensures that you're clear about who gets your assets and you can decide who gets what and how much share they receive. Having a will lets you keep your assets out of hands of people that you don't want to have them, like estranged relatives. Doing this is creating a disinheritance clause, which I'll talk about a bit later. Having a will also provides that your wishes in respect to your care of any minor children that you might have at the date of your death is something that you can control rather than leaving it for the courts to decide. So you can identify in your will who will care for your children. That's called appointing a guardian. Again, I'll talk about that a little bit more later on. In terms of estate plan and using your estate money on taxes and whatnot, having a will allow you to lessen the taxes that you have in your estate as well, because it will allow for distribution to your beneficiaries as opposed to the Guardianship and Administration Act dictating that. That can have a reduced impact on the taxes that your estate would pay otherwise. You can also make gifts and charitable donations, which will help offset your estate tax as well. Now, if you're creating a will to avoid tax liability on your estate once you pass, you should really get some taxation advice before you create your will. Now, primarily a will lets you dictate how your belongings, like your bank balances, your property or your prized possessions, will be distributed when you pass away. If you've got a business or investments, your will can specify who's going to receive those assets as well and when. In terms of making specific gifts upon your death, this is called a bequest. And it's a simple way to make a gift upon your death, and you can do this through your will. You're under no obligation to make a bequest to anybody when you do die, but if you do wish to make one, you can choose to make multiple bequests to various people or organisations and beneficiaries, or you can simply make one bequest to one particular beneficiary. Now, a bequest can be anything from cash, vintage cars, to your prized coin collection, anything that you own really that you want to gift specifically to a person. Your will also let you direct your assets to a charity if you're so inclined. Now, if your will sets out your wishes in terms of funeral arrangements or organ donations, the executor will need to make necessary arrangements for those upon your death in terms of your will. Now, speaking of your executors, this is the person who will handle your estate affairs once you do pass away and arrange the distribution of your estate. Now, you need to nominate a person who's still living at the date of your death to be the executor of your estate, and that person is usually a spouse, an adult child, or another trusted friend or relative. And they are responsible, like I said, for administering your estate. You can also name joint executors, such as your spouse and or a partner and your attorney, but this could create delays and extra costs if there's two of them as opposed to one. If you appoint more than one, they'll be appointed either jointly or severally, which means that they will have to act jointly in all decisions, or the opposite is that if they're appointed severally, then they can act in their own accord in terms of your estate assets. You can also appoint substitute executors. So if you appoint one executor and for some reason they're no longer available to carry out that job, for example, they've passed away at the date of your death, or they don't have the legal capacity to do so, or they simply wish not to take that role on. If you provide for a substitute executor in your will, then the secondary executor can come in if the first one doesn't want to do the job for whatever reason. Now, in terms of what the executor actually is, they are the person who's named in your will to carry out the wishes of yourself after you die, like I said. So they organise to collect all your assets and to pay all the debts of your estate, and then to distribute whatever property is left as set out in your will. Sometimes you can provide in your will that the executor will be paid for providing that service to your estate. If it's not included in the will that they will be paid for the work that they do, then they don't get paid, but generally they're able to use money from your estate to cover the necessary expenses, such as getting professional advice from accountants, lawyers, valuers in terms of administering your estate. Any costs that they do incur and charge back to the estate would of course have to be reasonable. So while you will generally address the bulk of your assets, some assets aren't covered by a will, particularly superannuation. Now, superannuation is a bit different in terms of it's not an asset, it's an entitlement, and the asset doesn't come into effect until it's actually been paid to whoever is the beneficiary of the superannuation. So upon your death, there's different rules for all super funds, and who gets paid your superannuation entitlements upon your death is generally dictated by the rules of the particular super fund. Now, if you want some more clarity on that, you should inquire with your super fund as to who is going to benefit from your estate when you pass away. Now, there's two scenarios. The legal personal representative of your estate could be one person that would benefit, and that would be your executor, or if you died intestate, your administrator. Otherwise, you can dictate from your super fund that named beneficiaries will receive your entitlements. Now, in order to do that and name beneficiaries, you would need to complete a binding death nomination. That's something you complete directly with your super fund, and it forces your super fund essentially to pay your super entitlements to the named beneficiaries when you pass away. It's important to note that a binding death nomination, however, is only valid for 3 years. So every 3 years you need to renew this. Excuse me. Now, in terms of assets that are jointly owned when you pass away, like the matrimonial home, your will might not offer the last word on how these assets are distributed. So in Western Australia, property is held in two ways. You can hold it as tenants in common in shares, or and that's how you would own usually investments, or joint, or the other option is joint tenants, which is generally how married couples will hold their property. With joint tenants, so tenants in common in shares, you'll each own 50% share, for example, of the property, and you can deal with that however you like separately. Now, with joint tenancy ownership, there's a survivorship principle, and basically that means that your spouse or the other owner will inherit the deceased party's share of that asset upon that person's death, and the asset bypasses the estate, so it actually doesn't form part of the estate assets. Now, if you own it in tenants in common, which is rare for married couples, but if you own property in as tenants in common, the deceased's share is going to be an estate asset, and the executor may force a sale of that asset to facilitate the distribution of the trust assets. That could render the surviving spouse homeless. So if the intention is that you want a particular person to inherit joint property, like your surviving spouse, and you own the property as tenants in common, it's important that you have a will so that you can leave your share in this asset to that person as a specific bequest when you pass away. Now, previously mentioned in regards to distributing your assets, in terms of appointing a guardian for your children when you pass away, if you've got minor children, so any children under the age of 18 when you die, you can stick in your will your preferences for who should take over as a guardian of these children. So although appointing a guardian in your will might help avoid disputes between family members by making your intentions clear about what you want to happen to those children when you die, it is not binding. A guardianship clause is not binding. The family court does have an overriding discretion to appoint a different guardian or remove a guardian of your child where they consider this to be in your child's best interest, but it's still a good way to put across your views on who you would like to care for your children in the event that you do pass away. Now, in terms of appointing a guardian, their role upon your death would be they would become responsible for the daily and long-term care and welfare of your child and making the important lifestyle decisions on those children's behalf. The guardian has an obligation to ensure that the child is adequately housed, clothed and educated. Guardianship of minor children is important. It's often an onerous task, and appointing somebody as your guardian should be taken quite seriously and thought through carefully. Before you make any change to your will, in regards to appointing a guardian, you should discuss the appointment with the person you intend to appoint and consider carefully whether they are prepared to accept that responsibility and whether they understand the views on how you wish your children to be raised. Now, there's generally in a will, there's a standard clause that will give your trustee, who's the executor, the power to advance income and capital from the estate, so funds from the estate, to the nominated guardian in terms of the maintenance, support, education and benefit of your children. So that means along the way that they can take money out of your estate to cover the costs related to raising your child if they've been appointed guardian. Now, once the children have reached a certain age, your executor can either pay the funds directly to that child, usually about 18, sometimes 21, sometimes 25, whatever suits you. They can decide to pay those funds directly to the child. Otherwise, until your children reach that age that they're ready to inherit from your estate, the executor usually would make payments to the child's guardian directly upon request to cover those costs, or perhaps they might pay them directly to the provider of any goods or services. It might be appropriate as well to make provision beyond that, so that your guardian can perhaps be provided a lump sum gift of money to extend their home or buy a car to help comfortably accommodate your children in the event they have to take on that role, to help facilitate them with giving them the ability to have your children reside with them in your home rent-free perhaps, or maybe one-off payments for them for acting as your guardian. So you can really go as far as you like with a clause in terms of the costs associated with raising your children. It's really up to you, but there is generally, like I say, a general standard clause that gives the power to the executor to take money from your estate to pay the guardian, so it's really up to you how you want to do that. Now, earlier I mentioned disinheritance. So disinheriting a child from your will in Australia is possible, but it's not necessarily a straightforward process. So disinheriting a child means that you're not leaving any inheritance to a beneficiary in your will that they would otherwise usually expect to receive. It's basically cutting off their entitlement to any share of your estate that they would otherwise expect. Now, there's some rules about what you can and can't do in this regard, but generally most children are given an inheritance from their parents when they pass away, unless the parent explicitly excludes them as a beneficiary, so explicitly disinherits them under their will. Now, it's important to note that if you do disinherit someone, the court can decide if the clause... It's important to note that the court can decide such clause in a will if it sees fit, whether to uphold that or not. It's really up to the individual, however, who created the will to decide if they want to cut an individual off, so one of their children perhaps off from receiving an inheritance. Some reasons where you might do that is where there's a lack of relationship with the child, or you believe that the child can support themselves adequately financially, whereas other children that you might not have the financial means to adequately support themselves. Some people use disinheritance as a tool for revenge or manipulation, which really isn't the right reasons to do it, but ultimately if you feel like you've got valid reasons to disinherit somebody who might otherwise benefit from your estate, you certainly have the right to do that. But like I mentioned earlier, it's ultimately up to the court to determine whether that clause should be upheld if the individual who's been disinherited challenges the will. So common reasons to disinherit somebody, where you've got a lack of relationship with that person, whether you believe that they have enough financial income and there's no need for them to inherit from you. If they haven't given you any support or cared for you at all in the past, or you haven't cared for them in the past, then you sort of feel like perhaps maybe there's no need for you to do that now. Perhaps you've already given them some financial aid throughout your lifetime and you don't believe that they're entitled to any further aid. Or maybe you don't support their lifestyle or their behaviour. For example, one of your children might be a avid drug user and you don't support their lifestyle, so on that basis you disinherit them. Now, if you're going to disinherit somebody, a relative in your will, you really should include a reason in the will for the disinheritance, so that you're basically setting out some reasoning as to why you've disinherited them, rather than just leaving it open-ended and saying, I'm disinheriting you, but I'm not giving any reasons why. It makes it easier for that disinherited relative to challenge it if there's no reasons provided. It is important to note, though, however, that if you disinherit them and you leave a reason in your will as to why you've done that, that's the last words that you're going to be saying to this person, so you just sort of need to take that into account. Now, adult children, like I said, can contest your will if they feel they've been unfairly left out by your deceased parent. It's for them to prove that they are entitled to claim from your estate or not, and that's something that the court will determine, the Supreme Court will determine. If the first step where somebody does contest an estate is that the matter should go to mediation and see if the parties can resolve it there. Now, if they can't, like I said, it's up to the court to decide. Now, in such case where there's a dispute, the onus lies on the child or the beneficiary, or proposed disinherited beneficiary, to make the claim to prove that they're entitled to a share of your estate. For example, if there's been a long estrangement between a parent and a child, and the child can't prove that they've made a significant and genuine attempt to reconcile with their parent before their death, the courts might decide that they don't have an entitlement under the estate. When making such a decision, the court will consider a number of different criteria, including like the current financial situation of the child, the length of estrangement, the reason that they were estranged, and whether the child or the parents have made a genuine attempt to reconcile the relationship. The size of the deceased estate will also be taken into account. Disinheritance is more common than one might assume. If you're considering disinheriting somebody from your last will, it is recommended that you think this through carefully. Not only is it a large statement to whoever you're not including, but it may also cause that person pain and hardship after your death that might not be necessary or intended. Now, if you decide to proceed with the disinheritance clause, you need to make sure that you're as specific as possible in your will to avoid confusion over your intended wishes. Alright, now it's important to let your executor know, I'll wrap it up now, so it's important to let your executor know where your original will is once it's been signed and stored away, along with any other information that they might need, such as passwords for a safe, passwords for bank accounts, that sort of stuff. It's wise to give a signed copy of your will to the executor, and perhaps your lawyer if you have one as well. But it is important that the executor knows where to find your last will and estate, the original copy of it, and that the original copy is kept in a good condition, not damaged at all. Never staple, pin, mark your will in any way. The original one is going to have to be produced to the Supreme Court with your probate application, and if there's any damage to it, then the executor is going to be in a position where they need to explain that damage and basically show the court that it hasn't been tampered with in any way in order for probate to be granted in your estate. So it's important that you keep the will and keep it safe, keep it with your other important papers that they might need. Just make sure your executor knows where to find it, and if there's any other important papers, it should keep it with that. Now, just quickly, marriage and divorce and your will. So marriage will revoke your will. If you get married and you've got a will, it's going to revoke your will unless that will clearly stipulates that it has been made in contemplation of this particular marriage. Similarly, divorce can revoke your will. This is a bit of a grey area, so if you've been divorced or you're contemplating, it's important to get legal advice regarding your will and the impact that your divorce is going to have on it. You should review your will every 2 to 3 years to ensure that it's current, or at any time where an executor or a beneficiary dies and the property is any property that's subject to a specific bequest is sold, or if you marry or divorce, or when you enter into a de facto relationship, all perfect times to review your will. Alright, I'm going to leave it at that, guys. Hope you've enjoyed this and you've learned something new about estate planning. If you do need advice or wish to update your will, please get in touch and we can book a free 1-hour consultation. Look forward to hearing from you guys. Have a good one. Thanks.